Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and casual listeners who want to better understand some of the hottest issues in these fields. Each episode is presented by one of the specialty committees within the section. This episode is produced and co-hosted by the Privacy and Information Security Committee of the Antitrust Law section. Today's episode continues our series examining different approaches to regulating artificial intelligence worldwide. Our focus today is South Korea. In December 2024, South Korea adopted the Act on the Development of Artificial Intelligence and the Establishment of Trust, set to take effect in January of 2026. It was the first jurisdiction in the Asia-Pacific region to pass comprehensive AI regulation, and the second worldwide after the EU. South Korea's AI Act aims to ensure domestic competitiveness while imposing regulatory requirements on high-impact and generative AI. It covers both businesses that develop or sell AI, as well as those that use AI systems developed by third parties, and it has broad extraterritorial reach. The Act also applies to businesses meeting certain threshold criteria that offer AI-powered services to South Korean users, or that use AI-driven analytics or decision-making that directly or indirectly impact the South Korean market. It categorizes AI systems into 4 tiers, with specific requirements for each of those 4 categories of AI systems. Now, the AI Act mandates transparency obligations on all covered AI systems, but the most stringent requirements are for so-called high-impact AI systems, which includes the use of AI in fields such as energy, healthcare, and public decision-making, among others. These high-impact AI systems must create comprehensive risk management plans and provide human oversight and disclose to users that the product or service involves the use of AI. Generative AI systems are required to label their content, particularly when mimicking real-world content, aka deepfakes. And additional obligations, such as a domestic representative, may be triggered for AI business operators based upon revenue and user size and computational capacity. Now, on September 8th, the Ministry of Science and Information and Communications Technology released draft implementation guidance. The draft guidance includes a multi-year grace period for compliance with the Act. It would protect from regulatory obligations companies that use but don't develop their own AI, thus placing the onus on the AI developer. And it would also set a high threshold for local representative requirements for foreign companies. So, has South Korea dramatically weakened its own AI regulation? And if so, to what end? Here to discuss these issues are my co-hosts for this series, Rory Macmillan and Nina Jayne Carroll. Rory is a partner at Macmillan Keck, based out of Geneva, Switzerland, and Nina is a competition litigation associate at Herbert Smith Freehills Kramer, based out of London. Welcome back, Nina and Rory.
Good to speak with you again, Anant.
Excited to be back.
So, Nina and Rory, throughout this series, we've examined the approaches to AI regulation being taken by different countries, and we've asked ourselves and our listeners, what is the right approach to AI regulation? And do the regulations we discuss accurately say AI as it exists, or are they reacting to hype that AI investors promise it will soon be?
Yeah, we've seen very interesting lessons from the European Union, from Brazil. We've had some big picture input from a couple of very leading thinkers out of Oxford and Columbia Law School. Here we are talking about South Korea, which is one of the few countries that's taken a serious effort at introducing legislation on AI. So we're delighted to have with us from the South Korean law firm of DR and Aju, which is rebranding with the new name of DNA, Yaera Jeon, who is a partner in the firm based in Seoul, but working extensively also in the United States, and so brings this perspective from both ends of the world here. Yaera, we heard from Anant a quick introduction to that basic law on AI, but maybe you could tell us a little more about its origins, its history, what it's trying to achieve, how it's organized, how it's going to work, please.
Sure. First of all, thanks for having me. And Anant, thank you for the overview of the Korea's AI Act. To start off, I will briefly overview the historical and political background of the Act, the structure of the law, and some more specifics of the obligation with the very recent, this week's announcement of presidential decree draft that elaborates what the law says. And after that, I think we can move on to a deeper discussion about the details. So the Korean government began its AI journey back in December 2019 with the announcement of the National AI Strategy. In 2024, Korea hosted the AI Seoul Summit in May, and the government formally identified AI along with semiconductors as Korea's key future industries, committing to becoming a global AI leader. The National Assembly of Korea has also been very active. Starting with the very first draft bill on AI technology development and industry promotion in 2019, there have been years of debate and nearly 19 different AI-related legislative proposals. All of that work culminated in January 2025 with the enactment of the Basic AI Act. The full name of the law is the Framework Act on the Development of Artificial Intelligence and Establishment of Trust Foundation. As the name suggests, this law is designed to serve two purposes: to build trust by regulating risks that AI may bring, and on the other, to lay the groundwork for AI development by providing government support and fostering industrial infrastructure. It is, in short, a foundational framework law for all AI in Korea. This law essentially aims at two things. As I just mentioned, the development of AI industry and building a foundation of safety and trust. But just this week, the government released a draft of presidential decree that will elaborate the law and also shared its direction for future notices and guidelines. And through this, the government made it explicitly clear that Korea will emphasize promotion rather than strict regulation, applying only the minimum level of rules through this AI Act. As we already knew from the law, given that only minimal administrative fines were provided for, the framework amounted to a low level of regulation. But I think it's significant that the government has openly committed to a minimum regulation approach and even announced a kind of grace period where fines will effectively be deferred in the early stages. However, it's still true that there are new compliance obligations for AI business operators, and here's where the criticism comes in. With only about 3 months left before the law actually takes effect, the government has only now published a draft of presidential decree. And the concrete details, the how of compliance, are still going to be left for future guidelines. For the regulated businesses, that inevitably creates a lot of uncertainties. The Act is organized into 6 chapters with around 40 provisions. Many of these focus on development, for example, how the government through its ministries and local governments will establish AI-related plans, support projects for AI development, and collaborate with private sector to promote the industry, and etc. And when it comes to actual regulation, the AI Act itself has only about 6 or 7 provisions that directly impose obligations on AI service providers. And if we include what's laid out in the draft presidential decree, the regulatory content can really be summarized into 4 main points. The first one is, if the AI is high impact or generative, obligation to ensure transparency comes in. This obligation includes advance notice to the users for both high impact and generative AI, and clear labeling in the case of generative AI. On this point, the presidential decree says that advance notices can simply be provided through terms of service or displayed on the user screen. For outputs generated by generative AI, the requirement is that they must be marked in a way that is either human readable or machine readable, which means that even invisible watermarks will count. But when it comes to deepfake outputs like synthetic audio, images, or videos that are hard to distinguish from reality, the rule is stricter. These have to be labeled in a way that users can easily recognize, whether visibly, audibly, or through software tools. And in doing so, operators are required to take into account the main user's age, as well as their physical or social conditions. However, these labeling and disclosure obligations don't apply in every situation. They are exempt, for example, when the AI outputs are used only for internal business purposes, or when it's already obvious from the service name or product label that high impact or generative AI is being used. And secondly, for large-scale AI providers, those trained with more than 10 to the 26th power floating point operations, they must first evaluate and mitigate risks across the entire AI lifecycle. And second, they have to establish a risk management system to deal with safety incidents. And thirdly, high impact AI is something that the Minister of Science and ICT gets to decide. And once an AI system is designated as high impact, the obligations go a step further. In addition to the advance notice requirements we mentioned earlier, providers have to publish key information on their website. That includes things like their risk management policies and organizational structures, the measures they have in place to protect users, a summary of training data used to develop the system, and the name and contact details of the person responsible for overseeing that high impact AI. And lastly, now this part is not a strict obligation, but for high impact AI, providers are encouraged to undergo an AI impact assessment. And there are, in addition to that, then there are these clauses on extraterritorial application and obligation to designate a domestic representative. In short, the law applies even to activities carried out abroad if they affect the Korean market or Korean users. And if an AI provider doesn't have an office or place of business in Korea, but reaches a certain threshold of users or revenue, the provider will be required to appoint a domestic representative. So these are the core obligations written into the law. And from here, I think it makes sense for me to wrap up and turn to the discussion.
Good. You mentioned that when it takes effect in a few months. What's the date when the act takes effect here?
It's January 26th next year.
And the decree that was published in early September 2025, is that just a draft, or is that what we know will take effect?
It's just a draft. And then now the ministry and the government is collecting the opinion from the market and from the experts. And then they will make the final draft, and then it's an official announcement. And then that will be made, it is expected to be made in October.
Mm-hmm. Okay, so one of the key things here is about high impact AI, and you mentioned that the minister decides what that will be. The law, though, I think I was just reading through it. It does have a basic list, which kind of has some similarities to some elements of the European Union's AI Act. It touches on energy, drinking water, healthcare, medical devices, nuclear materials, biometric information. And then broad areas around the impact on rights and obligations of individuals, like in employment, loan assessments, and then there's major operations management of transport and a few things like that. So there's a bit of a framework there given. Has there been much elaboration of that in this draft decree?
No. So as you just mentioned, all those basic things, basic definitions about, the AI system that has a risk of effect on people's life, people's security, and basic rights. That's the basic definition of this AI, high impact AI.
Right.
But presidential decree actually mentioned that it will consider the Ministry of Science and ICT will consider the severity or frequency of these risks. And then it will also consider the specific industries for use of this AI, high impact AI. So it was elaborated a little further, but it gives more discretion to the Minister of the Science and ICT.
And then unlike the European Union, which has a whole category of prohibited uses of AI, if I understand it correctly, there's no prohibition here at all. It's entirely a question of assessing risk, mitigating risk,
right,
carrying out risk assessments. Is that right?
Right.
Yeah.
And really, I suppose that feeds into the tone of the Act itself. It really focuses on industrial policy. It's more permissive than what we've seen in the likes of the EU. And that's definitely a topic that we want to touch on with you, Yaera, in a moment. But taking a step back from that, there's obviously a lot of technicality underpinning the provisions of this Act, especially with the recent announcement. But the reaction to the Act itself has been overwhelmingly positive in comparison to that of the EU, for example, presumably because of the approach it takes to industrial growth. So can you give us some thoughts on just generally the public opinion towards the Act?
So the reason why this presidential decree took so long to be announced, even the draft, was because there were a lot of debates on it. So from the NGOs or civil organizations, reaction is always the same. It should be more regulated. But the market participants are, of course, they are more into innovation and less regulation. And then that stays the same. And then from this announcement with the presidential decree draft, the government wanted to make it clear that it is supporting promotion of the industry rather than regulating it. And then that voice was more kind of evident because this ministry, this administration is a new one that came in this June with the new election. So it's the very beginning of their administration. So they wanted to kind of make their voice clear with this AI Act and AI regulation. And it wanted to give like clear message to the market that the government is not against or is more into regulating the market. So that's the tone of this regulatory system in Korea overall.
And I suppose you can see the similarities to the EU in that you obviously have a risk-based approach to a large extent, but then you do have this difference where you have, out of the approximately 40 articles that the Act has, 7 only regulate AI actors, and the remainder obviously focuses on guidelines. So we are seeing that push for industrial policy rather than regulatory guardrails, which is something we've discussed over the last couple of episodes. And that somewhat echoes the US approach when we look at initiatives in California and Colorado, for example. And we're seeing, again, a push towards industrial policy development. And I suppose the general reaction to that policy direction has been quite positive. I suppose that will benefit deployers and developers of AI, but has there been any discussion as to maybe the risk in taking a guideline approach rather than a more stringent approach, or what are your thoughts on that?
So for now, regulation about like prior notice or marking the result of the AI, generative and high impact AI, is still there. And the market participants are thinking that they anyway have to comply with it because the penalty clause is definitely, it seems minimal, and the government made it clear that they will defer its application. But still, the market participants has to follow the rule unless they want to breach it. So basically, they are thinking that still the guideline is not clear. But if we look on the privacy regulation, data protection, personal information protection, a lot of things are actually laid out in guidelines and notices. So, and then Korean government, especially in the privacy sector, they're very specific in giving guidelines and giving like certain instructions to how to follow it. So market participants' expectation is that we need some guidelines, like how to apply it, like in what sentences. Can you give us some examples of how we disclose it? What information exactly? So that's what uncertainties that the market is expecting to face.
So that really leads us into, I think, a very interesting topic, which is the style of regulation. We talked a bit about the industrial policy side. So that's about promoting business and AI clusters and so on. That's one thing. Staying for the moment on this regulatory space, and by regulation, I'm thinking rules, which you have to obey or not obey. And if you don't obey them, you're punished, right? So very simple concept of regulation. Here, in terms of the style of that rulemaking and of enforcing, I'm getting a sense of a very sort of collaborative process that's expected to be iterative, to evolve with time. There's some high-level provisions in the Act. Tell us about how that evolution is anticipated to happen. You just mentioned the privacy example, but I think you might tell us more about that. What are the institutions that this Act sets up? You mentioned the minister earlier. We understand there's a national AI committee. I think it's been renamed even as a national AI strategy committee, perhaps, which again brings in the industrial policy element. Tell us about the institutions involved here, how they work, and how you anticipate them developing guidelines.
So that is also something not exactly clear, it is clear that the Ministry of Science and ICT will govern this law. But let's say in case of fair trade and competition law, we have a special commission for that to regulate. And then they are very active in the market, giving out penalties and all. So in the privacy sector, we have PIPC, a separate commission that also regulate the market. And they're also very active in giving out guidelines or issuing penalties. Compared to that, AI Act only has the Ministry of Science and ICT, and the commission that you mentioned is currently under the president. And then the it is quite clear, especially by rebranding, like change its name and with under the new administration, this commission is quite clear about the topic that they will focus on. It's AI development strategy. So all the ministries under this administration are going to be involved in this committee to oversee all the different sections of AI. And this is more into promotion rather than regulate. So it is not still clear that if the ministry is going to take the whole power and act as other commissions like Fair Trade Commission or PIPC. So it is not still clear.
Do we know yet that commission, the National AI Strategy Commission, which, as you just described it, is much more about supporting growth of the industry? And I noticed that this legislation is actually billed as putting South Korea third in the world for AI. I mean, it's seriously ambitious effort to develop AI in the country. So this commission, tell us a bit about what we know about it so far. It's 40 or 50 people. Does it have powers, or is that it can come up with recommendations for the minister, or is that really not yet even established clearly in the law?
The commission's name has been rebranded as AI Strategy Commission. The law is only saying the National AI Commission. And under this new administration, they wanted to rebrand it, and then they wanted to expand their responsibilities and their role in the market. So they rebranded the name as National AI Strategy Commission. And with this, they actually mentioned that they will also amend the law to change the name. And also because the initial concept stated in this AI Act, it's actually from the previous administration. And then it's different from, they want to distinguish, like new government wants to distinguish itself from the previous one. And then they wanted to have more governance, and they want to strengthen their power in relation to the AI strategy going forward from the national perspective. So they are going to change the law, change the name, and also all the provisions that supports this organization, this commission, with the amendment of AI Act and also enactment of this presidential decree. So they actually, with the change of name and new foundation of this commission, they actually included more ministries. They expanded the engagement of the ministries that are involved in this commission. And then the government made it clear that this AI commission will show the overall direction of the national policy.
Right. So it sounds very much like it's refocusing even more on the industrial policy side of things. Just so there's a grace period, not yet specified, but for the enforcement and application of fines for violating the act. So the punishment side, that incentive for compliance is lightened or put off, in fact. And then I think, as Anant mentioned at the beginning, the threshold for foreign companies having to have a representative office within South Korea has been set quite high. $750 million US in annual revenues, something like that. I think it's a trillion won, or 1 million domestic users in South Korea using it. And you mentioned the computational capacity threshold also. So it sounds like the extraterritorial reach that this is trying to achieve is also, it's fairly light. It's only going to hit the big ones. Is that so? What comes through is a sense that the country's not really going to try to be very heavy in enforcing rules, obligations, and punishments. It's much more about building up an industry that's going to be trusted and succeed in the global market. Is that a fair way to describe it?
Yes, I would agree on your description. And the overall revenue applies to global revenue, but the number of user the threshold applies to the domestic users. and like 1 million users. It's for domestic users. And then this threshold is actually the same threshold that is now applied to personal information processing companies.
Mhm.
So that's the same threshold. And in addition to that, with this presidential decree draft, they added additional threshold. And then that's the revenue from the AI service related. So the AI service related revenue, if the threshold is 10 million, 7 million, considering the exchange rate, it's about $7 million US per year. So that's the threshold that's been added on top of the other regulatory system that's been already in place.
Okay. And so then just on the fines, is if I've read it correctly, they're about, for a violation, they're something like 22,500 US dollars equivalent of the Korean won, which is a very small amount compared with, well, take, for example, the European Union Act. But I think also you mentioned the severity of penalties for fair trading, for competition law in South Korea, and for personal information, data protection in South Korea. Do you expect that with time, as this industry grows, as this commission, which is responsible under the Act for the whole range of regulatory aspects, do you expect that the enforcement engagement might strengthen over time like it did with personal information protection? Or do you think that it's really going to stay very limited given the what the Act says?
It really depends on how you expect the future. But I, like personally, as we've seen with the personal information regulation, the regulatory system's stance is quite different from the very beginning, because personal information was there from the beginning that it will regulate the market. And then this is more into promoting the development of the industry. But still, there are these penalty clauses, and then there will be more specific guidelines coming out. And then it's already announced that the guideline will be issued. Some guidelines will be issued toward the end of this year. So there will be more specific guidelines how the market participants should follow. And accordingly, I think the penalties will be more. For now, the main penalty is only applied to the prior notice clause. So it applies to like very limited breaches.
That's the transparency. That's the transparency requirement to tell consumers this is an AI product you are now seeing or using. That prior notice requirement.
Exactly. So that disclosure requirement is the only actual, and then also local representatives. Those are more practical penalties that the business operators should expect. Mm-hmm. But going forward, the regulatory requirements will be more specified, and then the kind of concept of what to regulate in the market will get more specific. And then as the market participants can expect more specific items, it'd be easier to notice breaches in the market. So it will naturally go down the path of getting more regulatory system in the market. That's what I could kind of see. But just to make it clear, it's the administration is now in place just this June. So it's the very beginning of this administration, and it will be there for the next 5 years. So the current stance will be maintained for throughout this administration, I bet. So it's not like when I say it will get the regulation getting more specific or getting more increasing of penalties and so on, it's not expected in the near future. But in a long-term perspective, that's the path that the personal information regulation has been come down. And I kind of expect that it's going to be quite similar, but in a longer time sense.
So given the light approach to actual enforcement of obligations this act is taking, at least at the beginning of its life, I've seen some people saying that really the action is going to be less, the enforcement action is going to be less with the AI Act here and more with the Protection of Personal Information Act when dealing with AI systems. So, for example, in the European Union, what we've seen is a number of enforcement actions brought by countries like Italy, Ireland, France, the Netherlands, dealing with the way AI systems are using personal data. And the European Union's Personal Data Protection Board has also weighed in, giving guidance on how should AI systems use or not use personal information about people. And I'm curious here whether you expect there to be quite a lot of enforcement action on the personal information protection side. So less under this act and more under that. Tell us about that.
That actually is a really good point, because PIPC in Korea, that oversees the personal information regulation in the market, it's very active. And then they are very active in putting out all the guidelines and very specific policies that the market participants have to follow. And then there are already a few guidelines in the market. So they are saying that it's related to personal information. Of course, they are related to personal information, but especially on generative AI, they've been already putting out guidelines related to how to use how do we see open information in the market from the personal information protection perspective, and so on and so forth. So as you mentioned, it already has power in the market, and then they are putting out guidelines already. So we can expect it might be easier to see more specific regulations from that side.
And to round out the discussion that we've just had, we wanted to, instead of focusing on what's happening now, is to kind of take a step back and look ahead at the potential impact that this approach of regulation will have. So some of the negative pushback that we've seen on the direction the EU has taken is that it obviously risks stifling innovation because it's so stringent. And Korea's approach to AI is significantly more permissive. You noted the minimum regulatory approach that the government recently announced at the start of this episode. So do you see the possibility of an influx of AI business into South Korea and away from the EU, given the difference in approach, or what has the reaction been in that sense?
That's what the intention behind this government announcing that they will be promoting the AI industries. And also the government is kind of clear that they will also see what other regulatory jurisdictions do in the market. And they are well aware of the direction of the EU's approach. And then they're also looking into Japanese regulation and also the US regulation. They also mentioned that in their announcement as well. So they are very concerned about what other regimes are doing. And then from that perspective, it is kind of clear that they want to get the influx from other countries if possible. And also they want to promote the Korean companies to go overseas and then not getting any hindrance by the Korean regulation holding them back. So that's what we can expect from in the market, I think.
Nina, the question you asked is very similar to a thought that I had. We know that policymakers are concerned about societal harms from AI, but at the same time, they also see it as an economic driver for their economies. And I was struck by the lack of severity in the draft guidance that came out from the Ministry of Science. So Nina, Rory, thinking back to our rousing debate in the first episode we had in this series between Professors Anu Bradford and Victor Meyer-Schonberger, do you think this direction by South Korea policymakers is a race to the bottom or a race to the top?
I think, honestly, now that we're at episode 4 and we've considered the EU, Brazil, now South Korea, we obviously had the overview episode as episode 1, and we're yet to even touch on the US. What we're seeing is that there's a menu of options available for policy makers and regulators in this area. And while there are some similarities, they're vastly different. I don't necessarily think you could characterize it as a race to the bottom or a race to the top. Rather, it's a race in which each regulator views as an entirely different race, depending on what its aims and goals are. The EU is obviously driven by referring to the AI as a technology generally as a black box. In some sense, we've seen that it consistently been referred to as that. Whereas in other jurisdictions, for example, South Korea, now we can see there's a more permissive approach being taken. So I don't know, is each regulator in the same race potentially, or are they in different competitions and they have different aims driving it forward? I think that would be my take on it.
Yeah, I think we've seen the tone globally change on this from a tone of alarm where CEOs were begging governments to intervene and regulate and protect the world against the catastrophic risks of AI. In the last year, we've seen that shift to not a free-for-all, but certainly a much more business-oriented approach. And that's certainly what's coming through, not just in the original structure of the South Korean Act here, but actually in the moves that we've seen since the new government's come in, and the new draft decree has come in, the renaming of the commission handling it to be really much more about strategy. It looks like this is very much about building up AI as an industry. And I imagine there's a lot of trust that for that to succeed well, it will need to be trusted AI anyway. It'll need not to be too dangerous, because if it were, it would lose the trust. And I think there must be a lot of trust in business to do it well. So this is a clear example of a much more, as Nina said, permissive and I think collaborative style of regulation, learning as they go. And we will see as the risks materialize, if there are any serious harms done, then perhaps we'll see things tighten. There seems to be flexibility in the Act to adjust that.
So we like to wrap these episodes with a few key takeaways for practitioners. Yaera, let's start with you.
So this AI Act is, as mentioned earlier, it's the second AI Act that regulates the AI industry. And then Korea wants to take a lead in this industry by showing that they will highly support the AI industry, and then they want to grow with the AI. So with this regulation, they are into support the industry and promote the industry with the act. And that's the overall direction that we can expect to see in the market for a while in Korea. So from that perspective, it's a law that the business operators should, of course, they should be aware what are the obligations, but we have to carefully look at the development of the law, how it's going to specify, and then how the ministry will specify with their guidelines and notices. So we can expect to see more developments in the market. This is a very beginning of this law from the perspective of stage. There's a lot more space to grow or develop or specified. So we have to take a look what's going to turn out with this regulation.
Rory?
Yeah, well, this is clearly a risk-based approach. That's the structure of the obligation. It's identified high impact, which the EU thinks about as high risk, but it's the same kind of underlying notion. Types of usage of AI, and there are the obligations to be transparent about that, to mitigate risk, to analyze it, to carry out in serious cases impact assessments. So there's some of those common themes that are coming through. But for practitioners, I think they'll need to keep their eye on which of their clients fall within the high impact AI categories. But the risk to their clients of serious adverse enforcement seems to be low. Maybe there'll be important reputational risks to manage in this. But I think the key thing is this is a moving target. This is an evolving process, as Yaera has described to us, and the way that the personal information protection legislation evolved over its, I think, 13, 14 years suggests this could evolve significantly over time.
And Nina?
I absolutely agree. And I think it shows that some governments and policymakers are willing to grow with businesses developing this technology to build trust, as Yaera mentioned, rather than to solely legislate in a stringent way. And it's a real signal to those working with AI that there, as I said, a menu of options out there in terms of regulations, and that maybe every risk-based approach won't be the same. So whether it's a race to the bottom or a race to the top isn't clear, but that's something that we will look to consider further and monitor really as we move to discuss other jurisdictions such as the US, particularly in future episodes.
Thank you, Yaera, Rory, and Nina, for this excellent overview of South Korea's new AI Act. As we do at the end of every episode in this series, we encourage all of our listeners to think for themselves, what is the right approach to AI regulation? To our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.